Good morning, everyone. Title IX was enacted in the early 70s to create gender equity in the scholastic area, mostly in the matter of student athletics. More recently, Title IX scope has been broadened to where instances of student-on-student sexual violence and harassment are now considered to be Title IX violations. And in the wake of such violations, school and community college districts not only face civil actions that have cost our super pool members over $8 million through the last 5 years, but also might have their federal funding suspended. In today's webinar, Dennis Walsh will cover Title IX's impact on sexual harassment and its requirements to mitigate and investigate. Many of you are very familiar with Dennis Walsh, as he's an employment practices attorney for Southern California Relief and SWAC. He has specialized in civil litigation and labor and employment law for over 26 years and has successfully defended employment cases and tort liability cases at trial, including sexual harassment lawsuits and discrimination claims based on race. He's argued before the California Appellate Courts and the Ninth Circuit Court of Appeals on public agency employment law issues. And he's also appeared on the O'Reilly Factor and other news shows to discuss important legal issues. Now with that, I'd like to turn it over to Mr. Dennis Walsh.
Thank you, Marco. Good morning, everybody. As you can see from the title, we want to talk about what the impact of Title IX is on student-to-student sexual harassment. But as we go through the agenda here this morning, I'm going to broaden it a little bit because I think that for those of you that may not know, I think it's important for you to know that Title IX just does not impact student-to-student sexual harassment. It potentially impacts teacher-to-student sexual harassment, and it also impacts other forms of harassment. It's not just limited to sexual harassment. It includes harassment based on race and other protected classes. So we're going to try and cover this as if we're not just talking about sexual harassment, because whatever we talk about here today would equally apply if you said you had a situation where there was racial harassment, student-to-student or teacher-to-student as well, or any other types of harassment in the school setting. For many of you that may not know, the interesting part about Title IX is that it was initially enacted to protect students from discrimination based on sex in education programs and activities, and the entities that are covered are any entities that receive federal financial assistance. So I can assume that everybody that's on this call is one of those entities, and therefore clearly Title IX applies. It is a federal law, however. It's not a California law, which means that it applies to all the states and not just California. So typically, when we do see a Title IX claim, it will be filed in federal court and not in state court, which is normally the place where any sort of federal issues are decided. And as Marco alluded to, initially Title IX was rearing its head in litigation in the form of athletic support, meaning that there were gender-based decisions being made in football programs and basketball programs and other athletic activities where mostly women were arguing that there was discriminatory treatment because they were not receiving equal treatment in terms of assistance, in terms of supplies, in terms of dollars to support their programs. But as we've seen over the years, the courts have found that it is limited only by the word discrimination, and therefore discrimination, as we know, can take on more than just discrimination in terms of benefits and opportunities in the athletic setting, but clearly is defined as encompassing benefits that encompass all of your educational opportunities that a student may have. And so as I said earlier, we're not just limited to sexual harassment. It can be race, color, creed, etc. And by way of background, the statute was modeled after Title VII of the Civil Rights Act of 1964. And as many of you probably know, Title VII was the initial federal law that protected employees in the workplace from discrimination and harassment based on race, sex, color, creed, etc. Of course, we now have our own laws in FEHA that handle that. And really, the main distinction between Title IX with regard to students and Title VII, which is regarding employee discrimination and harassment, is that clearly Title VII is designed to be a compensatory statute, meaning you were damaged and now the entity has to pay money to compensate you for those damages. The focus of Title IX really is on protecting the individuals from that discrimination and that harassment. And as you're going to see later on in the presentation, that's a huge distinction, because the focus for Title IX is really not on the conduct, but what the entity does about the conduct. And depending upon what the entity does or does not do about the conduct will determine whether or not there are going to be any compensation or compensatory damages to the student or the victim. In terms of who can violate Title IX, the alleged harassers, so to speak, or defendants, as we call them by the time I get the lawsuits, are very similar to those that you would see in an employee FEHA case, a discrimination and harassment case. It can be the entity itself. It may be a teacher, if it's teacher to student. It could be, it can be third parties. But keep in mind that for purposes of Title IX, as I'll tell you earlier, the defendant has to be, for purposes of a Title IX violation, someone who receives federal funding. So by its very nature, that's going to eliminate some defendants that you would normally see in FEHA cases. But in terms of how they're generated, you're typically going to see harassment by students toward another student, or harassments by teachers, staff, and third parties toward another student. And the real question becomes, what liability is your entity going to have, whether it's a school district or a community college, in terms of exposure for any such harassment by these third parties? We're going to go into all of this in detail, but the recovery against schools and colleges is really limited to a very finite set of circumstances in terms of your conduct, as opposed to whether or not there are any damages. And we will go through all of the actual elements of the claim in order for someone to succeed. But in terms of your conduct, there's two really important aspects to that. Number one, was there adequate notice of the behavior? And number two, was there deliberate indifference to the harassment once that behavior became known by the entity? And really the focus, again, as I pointed out, is the issue becomes what have you done to take action after the conduct, rather than imposing liability against the entity for the conduct itself. Now, that's what Title IX does. Right? What you have to understand is that it doesn't prevent someone, however, from making other claims as part of the litigation. And what I mean by that is it's not unusual for us to see a Title IX claim where a student is claiming harassment by another student, or in a case, a situation where they're claiming harassment by a faculty member or a teacher in the area of sex or race. And we'll talk about some of those scenarios a little bit later. Now, Title IX, as we'll talk about, the elements of that claim, again, are going to focus on adequate notice and what the entity did about it, which may affect whether or not the victim is going to be compensated. However, that doesn't prevent the victim from making other claims against the entity, which have a whole different set of standards and impose different liability. For example, they may allege in the situation involving a teacher who has been sexually harassing a student, negligent hiring, negligent supervision, or negligent retention. And so there are other claims that can be made against the entity that don't fall under the purview of Title IX and may in fact impose liability even where Title IX doesn't impose liability. So Title IX by itself is generally not the only claim we see, at least related to student to teacher. Now, student to student, obviously those claims can be made against another student, but you're not going to see a claim of negligent hiring, supervision, or retention against the entity based upon student to student harassment, since obviously those students are not employees of the district. So it's unless there's going to be some evidence that the district was aware of the student's behavior time and time again and did nothing about it, you may see a negligence claim, but it's going to have to be based on some violation of a statute. So the liability for student-to-student harassment, apart from a Title IX claim against your entity, is going to be a lot less than if it involves a teacher. Now, as I said earlier, Title IX does not permit suits against the actual harasser themselves because they're not direct recipient of public funds. But again, if it's a teacher and or another student, these are the other claims we will typically see against them. If it's sexual harassment, we'll typically see assault and battery claims against them individually. You can also see what we call intentional infliction of emotional distress claims, and they also will sometimes try and allege a civil rights violation claim because those claims can be made against the individuals. So those are typically the other types of claims we see. So to sort of pull this all together for you, it's not going to be unusual for us to see that the entity will be named in a lawsuit and the individual harasser will be named in the lawsuit. It's just a question of what claims you're going to see against each. And if it's the entity, you're going to see a Title IX violation and possibly claims of negligent hiring, supervision, and retention. And if the individual is also named, you will not see a Title IX violation against the individual, but you may see claims of assault and battery, intentional infliction of emotional distress, or violation of their civil rights. Now, these are the actual elements that a plaintiff suing under Title IX will have to prove in order to succeed. And we're going to go through each and every one of these individually as we move along. But therefore, actual notice, deliberate indifference, severe, pervasive, and objectively offensive harassment, and deprivation of educational benefits and opportunities. So for those of you that are aware of what the standards are in an employee sexual harassment case, for a hostile work environment, you can see that these are completely different elements that have to be proved when a student is claiming harassment either by another student or by a teacher or someone else against the public agency. So let's dissect each and every one of these to give you an idea of what we're talking about. Actual notice is a really important aspect of this. And unlike employee harassment, regardless of who the harasser is, student, teacher, administrator, board member, it doesn't matter. Schools and colleges will not be held accountable for monetary damages under Title IX in the absence of actual notice, not just by anybody, but by somebody at that district that has the authority to institute corrective measures on behalf of the entity itself. So, for example, it's not going to be enough that the custodian knows that the harassment is going on student to student or teacher to student. It may not even be enough for the principal to know, because it has to be somebody that has the authority to institute corrective measures. Now, if the principal has that authority, then it's a different situation. Generally speaking, though, if you review most of the cases, when you're talking about who has the authority to institute corrective measures, you're typically looking at someone above the level of principal. You're looking at district officials more than anything, because that's typically where the complaints come from, and that's typically where the actual notice is intended to be directed, because as I indicated earlier, Title IX focuses on what is the entity doing about it, not just a particular school or location. And when I point to the fact that agency principles really don't apply in Title IX, what that means is that if, for example, you have a teacher who is sexually harassing a student, because the teacher works for the district, that does not imply actual notice to the district. Now, how does all this fit in with just to sort of contrast it with employee harassment? Well, first of all, in the instance of employee to employee harassment, co-employee to co-employee, actual notice is not required. The standard is knew or should have known. So even if you don't have actual notice in an employee to employee situation, if you should have known it was going on, i.e. everyone else did, it doesn't matter whether you had actual notice. So there's a key distinction. In supervisor to employee harassment in the employment setting, you don't even need notice. You're strictly liable for the behavior whether you knew about it or didn't know about it. So clearly when it comes to student harassment, there's a much higher standard imposed in order to find liability against the entity. And as I'll talk about a little bit later, hopefully we'll get to a couple of factual scenarios, you can see how we can get out of these cases if the right action is taken upon actual notice. The second standard that has to be met, and it's a very high one for someone suing an entity for Title IX violations, is whether or not they can prove that the entity was basically deliberately indifferent to the notice of this harassment. And really what that means, in the short of it, is what did you do? And most of the cases you look at will pretty much say, although they don't quote it, that the standard is pretty much doing something more than nothing. You know, I think there are some arguments to be made that you almost have to ignore the behavior in order to be responsible. Now, the reason I say that is because I know for a fact, or at least I'm hoping I know for a fact, that everyone on this webinar doesn't ignore complaints of harassment by students. So the question then becomes, you know, what do you have to do? All right, and we're going to talk about that a little bit later, but if most of you are conducting an investigation and finding out what's going on and doing it the way it's supposed to be done, as we'll talk about later, it's going to be very difficult for the court to find that you were deliberately indifferent. And as we go through one of my factual scenarios, I'll point out to you how the other side tried to sort of expand or illuminate the court on what deliberate indifference should mean, other than simply doing an investigation. And that case went up to the Court of Appeal, and the Court of Appeal disagreed. So we'll talk about that a little bit later. But that's the second part of it. So those the two first elements that we discussed, actual notice and this one, deliberate indifference, go to the conduct by the entity and what your obligations are. So first, it has to be known by someone who's in a position to do something about it, and then the question is, what have you done? Now the next elements really go to, how has this impacted the student himself? But before I get there, let's talk about it, what would be an example of deliberate indifference. Okay? No Title IX violation by reason of a teacher having engaged in a sexual relationship with a student because the district did not have actual notice of the relationship. And that should actually say example of no deliberate indifference. Nor were they deliberately indifferent when the teacher was fired when the district learned that the teacher was making inappropriate sexual comments in the classroom. So in this particular instance, this was a case where a teacher had a sexual relationship with a student. The district, it was not proven that the district knew about the sexual relationship, but the district did know that the teacher was making inappropriate comments in the classroom, and when they found out about those comments, the teacher was immediately fired. And the court said that's not a Title IX violation because that doesn't show deliberate indifference. So in this situation, there wasn't even an investigation done. The immediate action was taken to remedy some form of harassment, and the court found unless you could prove that the district had actual notice of the sexual relationship and did nothing about it, that there was no Title IX violation. This situation would be no different if we were talking student to student. If you had two students that were having a sexual relationship and no one knew about that, and then later on that student is expelled or transferred or disciplined as a result of making inappropriate sexual comments, and the other student tried to sue for Title IX violation based upon the sexual relationship, the standard would be no different. I think the court would still find that this is not an example of deliberate indifference. All right. The third element of a Title IX violation, and this is imposed upon the victim, and not much different than you see in a sexual harassment cases, severe, pervasive, and objectively offensive harassment. Now, where the distinction comes in here is because we're dealing with students, whether it's in the K12 setting or the community college setting, is going to make a world of difference as to how this particular element is illustrated and how it's proven, because it's going to depend upon a number of circumstances that generally have nothing to do with employee-to-employee harassment. Number one, the age of the harasser and the victim, especially when you're talking about student to student, is going to be a huge factor. Are we talking about, you know, a 16-year-old sexually harassing a 10-year-old? Are we talking about 2 second graders kissing each other, or 1 second grader kissing another second grader? You know, a lot of that's going to determine whether or not it even rises to the level of severe, pervasive, and objectively offensive. The number of individuals involved is going to have some impact on whether it's objective. Are we talking about 3 or 4 people sexually harassing one particular student, or are we talking about just one-on-one? And obviously, the severity and frequency of the conduct is going to make a huge difference as to whether or not it's pervasive and offensive. That's not dissimilar to a standard that is imposed in employee-to-employee harassment. You know, how bad is it, and how often has it been going on? And then lastly, which is the last element of this, but we'll talk about, is the effect it has in depriving a student of any educational opportunities. Now, there are a number of cases out there on Title IX, and because, as I said earlier, Title IX is a federal law, not a state law, there's a number of cases outside of California that we can use as illustrations of whether something is or is not a Title IX violation, which is a good thing because California tends to be somewhat more liberal at times than other jurisdictions. But you know, clearly we're not talking about simple acts of teasing and name-calling, even if they're related to someone's gender. I mean, ultimately, you know, they may not be severe enough because the behavior has to have, and this is a quote from most of the cases, a systemic effect of denying someone equal access to an educational program or activity. So unless they can show that an isolated instance has a systemic effect of affecting someone's educational opportunities, you know, typically name-calling on 1 or 2 occasions or teasing is not going to fit. But again, it's going to depend upon the severity and the frequency of that conduct. So basically, you're going to find that this is going to be more of a case-by-case basis. Now, let's talk about the age factor, because I'm sure a lot of you who are certainly in the school district setting are wondering, okay, you know, how does this all work? Well, you know, in terms of elementary students, just to give you an example, you know, if you have an elementary student, you know, we always try and argue that it's not offensive because it's welcome behavior. Well, the courts have found that when you're dealing with elementary students, they don't have the mental capacity to welcome any form of behavior. Now, of course, you know, that may change if we have a situation where we have, you know, parents that are complaining about Title IX violations because their 4th grade daughter was, you know, repeatedly kissed by another 4th grader, and we found out that the fourth grade daughter admits that she asked the 4th grade boy to kiss her. That may be a different situation. You know, with secondary students, when it comes to sexual conduct, it's generally found that it's not consensual behavior. You know, as they get older, and I can't give you, there's a sliding scale basically, but there's no set things that, okay, from, you know, kindergarten to 2nd grade it's X, from 3rd grade to 7th grade it's X. There really isn't. But the cases that I've gleaned show that, you know, when you're talking about older secondary students, a lot of it's going to depend upon the nature of the conduct, the relationship of school employees to students, legal consent by students in question, and of course, if you're dealing with college students, you know, if anybody's really over the age of 18, you've got adults, so the age factor is really not going to play a role in determining whether or not any of this is pervasive, okay? And so, as I indicated earlier, you know, whether or not you're going to try and argue it's not offensive because the conduct is welcome is really going to depend upon both the age of the student as well as the age of the harasser, and that even goes in the college setting. I mean, in the K12 setting, obviously, you know, it's not going to be a defense that, well, you know, she's 16 and the teacher is 21. You know, I've had many cases like that where we've had assistant coaches that are volunteers that are 21 and they engage in relationships with students. I think when we talk about the age of the student and harasser, we're talking more student to student, especially if the student is under the age of 18. So obviously if the student's over the age of 18, and obviously we do have kids in high school now that are over the age of 18, that's certainly going to play a role. And obviously the nature of the conduct and the relationship of the parties is going to play a role. You know, I can't tell you how many cases I have, and in fact I think I have one now, where we have two students that are in high school, both are under the age of 18, and parents have found out that there was a sexual relationship involved after the parents didn't want the female student to be seeing this particular male student. And so, you know, that's going to play a big role. The consent between the two of them, the fact that it was a voluntary relationship, that they're the same age, that they were boyfriend and girlfriend for a period of time, those factors are clearly going to come into play when the court's deciding whether or not this was, you know, objectively offensive and severely pervasive for purposes of whether there was a Title IX violation. I get a lot of questions about physical touching. And you know, this is not to talk about the obvious things that are physical touching that would be clearly seen as a violation, whether it's between student to student or teacher to student. But you know, we all realize that there is legitimate non-sexual touching or other non-sexual conduct going on from time to time. And of course, the first question I get is, and this is the example, you know, is it illegal now for a coach to hug a student who just made a goal in soccer? And you know, how about demonstrating a sports maneuver or technique that requires contact with another student? Well, no, legitimate physical touching for legitimate needs is fine, all right? But given the age of the students involved, there has to be some caution in terms of what type of physical contact you have and whether that physical touching or contact is really necessary. The other caveat to this is there are many instances where I've seen non-sexual conduct takes on sexual connotations and becomes sexual harassment. For example, you know, you get a faculty member who's repeatedly hugging or putting his arms around certain students in inappropriate circumstances. You know, where they're using the opportunity to get close to them because they want to learn how to do something on the computer, or they're looking at some highlights in their book, and they take what would otherwise be a legitimate circumstance and use it as an opportunity to be involved in inappropriate behavior. And I point that out only because it should not be discounted when a student complains about the fact that there was some inappropriate activity with a faculty member or another student, and the first answer you get from the alleged harasser is, look, we were going over homework. You know, we were practicing a sports maneuver or technique. You know, there may be a little bit more to that, and there is an example of whether or not someone's going to try to say you were or were not deliberately indifferent to what the conduct really was. So just be aware that, you know, of any sort of legitimate physical touching and whether or not it's gone to the level of being inappropriate. Obviously, as I indicated earlier, you know, the more severe the conduct, the less the need to show that it was repetitive or that there was some frequency. You know, typically if you're talking about with students, and we see a lot of this grabbing parts of the body. Obviously, though, keep in mind that a single instance may be enough if we're talking about actual sexual behavior or even sexual advantages or sexual advances. But, you know, not all conduct is going to be considered hostile to the point where you have to be concerned. You know, it's not, this part of it is not much different than the employee setting. You know, a comment from one student to another that, you know, they have a nice body, or a request for date, or flowers, you know, unless those things are repeated and get to a point where they're bothering somebody, and we're going to get to that factor in a minute, you know, those by itself are not always going to rise to the level of a situation where action is going to have to be taken. And the unfortunate thing about this is there really isn't any set answer. You know, everything's going to be determined on a case-by-case basis, and the importance of making that determination from your perspective when we talk about investigation is getting as much detail and as much information as you can, not unlike an employee-to-employee sexual harassment situation. A lot of times people want to know, does it only have to happen at school? Well, this, again, is not any different than employee-to-employee harassment. Is it taking place in a context or location subject to the school's control? all right? Clearly on school grounds during school hours is a no-brainer. But what about off-campus? What about, you know, the ride to the soccer game? What about the soccer game at another high school? What about the off-campus parties? What about the prom that's you know, over at the you know, the banquet facility? Well, again, the question's going to be not unlike the employee Christmas party or the office Christmas party. Is it a context under which the school controls the event or has some control in the event? Obviously, if it's a school activity, the location doesn't matter. It's still a situation that you have to be aware of. Question I always get, what happens if a student takes another student home in their car from a school-sponsored activity and the sexual misbehavior happens in the car on the way home? I don't believe that the courts are going to find that to be an example of taking context of a situation in the school's control. Now let's change it a little bit. What if the soccer coach asks his assistant coach to drive this individual home and suddenly we have some inappropriate behavior going on? That might be enough to change the scenario a little bit, because now it's a situation where maybe the school has taken a level of control, and of course that's going to depend on whether or not the coach should have done that, had the authority to do it, was part of policies and practices. But most of the time, I think, if there's any direction like that taken by somebody who works for the school, there's going to be an argument to be made that that was within the student or the school's control. Okay. When is it not severe enough? Well, this is an actual case where there was a teasing of a middle school homosexual student, including a teacher calling him fruity on one occasion in front of the classroom. Now, that wasn't enough to be severe or pervasive. Now, what this case does also illustrate is that when we're talking about sexual harassment, we're not just talking about male to female, female to male. We're talking about sexual orientation as well as gender type harassment or sexual conduct harassment. So again, not a employee-employer setting, it's going to cover all of that. It's also going to cover any bullying that's taking place based upon someone's sexual orientation. And we've seen Title IX cases come up that way as well. This case is an actual case, and I'm not going to read all this to you, but you can look at it because this is an example of unbelievably abhorrent behavior by a girls' soccer coach, and I took this right out of the case. I mean, this is beyond severe, and how this kind of stuff even happens is kind of crazy. But again, the conduct may be severe, but the reason I want to illustrate this particular case, if you as an entity find out about it and take immediate action and are not deliberately indifferent, the entity is not going to be responsible under Title IX. In fact, the entity will be able to get out of that case on Title IX. Of course, the question is going to be whether or not you negligently supervised, negligently hired that individual, whether you knew this individual had a propensity for that behavior before and didn't do anything about it. But in terms of whether or not, you know, conduct can be severe, when you're talking, I would say that any one of these bullet points by themselves might be enough at least for them to argue that the conduct was sufficiently severe. The last element of these claims that's very important, and again is sort of a gray area to deal with, is that assuming we have all those other elements in place, that there still has to be a denial of some sort of educational benefits or opportunities to the victim. And that's going to be done on a complete case-by-case basis, and it's really going to be based upon the totality of the circumstances. And unfortunately, there's no black and white rule on whether or not the student has been, in essence, damaged. Now, you know, typically when we have these cases, it's not unusual for us to see the obvious tangible injuries. You know, you can see a student suddenly went from an A-B student to a C-D student. You can start seeing that the student has emotional problems. You know, we can see that the student's not, you know, dressing well, they're not taking care of themselves. You know, they're actually treating with a psychiatrist or a psychologist. But one thing the courts do look at is you know, there's almost this implied severity rule that the more severe the conduct, the less the damages have to be proven. It's almost like, you know, it's implied that someone's going to be damaged whether or not they're showing actual damages or not. If someone were talking about, you know, sexual assault, we're talking about sexual activity or repeated bullying or things of that nature based upon, you know, sex or race or orientation. So, again, it's really going to depend upon what the circumstances are. And but keep in mind that the courts don't require an obvious injury. All right. I mean, I've had cases before where I've seen that the student's grades were exactly the same. And when we discussed that with the student, you know, the student came back and said, look, you know what? I was not going to let this affect my ability to continue to get good grades, and I just had to work harder. I had to spend more time on my homework, more time studying for my tests, and I got through it despite the fact that, you know, I was crying once a night. So that by itself is not going to be an end-all or be-all to whether or not the student was damaged. And, you know, plenty of students will say, you know what, I stayed on the soccer team even though I was being harassed because, you know what, I wanted to play soccer and I wasn't going to allow this person to get the best of me. So it depends upon what we're going to hear from the student in terms of whether or not they were or were not denied educational benefits. These are some examples of where there were no denial of educational benefits. Second grade male student was bothered and teased, put his hand on a second grader's vagina for a quick second. Believe it or not, the court found that because she only missed one day of school and she was moved to another classroom away from the male student immediately and continued to receive satisfactory grades and didn't get medical treatment until after her mother filed a lawsuit, the court said, you know what, this is not enough to show a denial of educational benefits. Now, some people would look at this and say, why not? But I think a lot of it has to do with how the case is presented and how badly the individual truly is affected. And my guess on a case like this is that when the court looked at more than just these bullet points, the court probably saw this more as an opportunity for someone to get some money and pay for college education than a situation where somebody was really truly damaged. But, you know, I've seen that. We've seen that happen before as well, and that's unfortunate. But this is a case where there was plenty of deprival, and this wasn't of educational opportunity, and this wasn't even a sexual case. This was physical attacks against somebody based upon their gender, and there were kicks and punches to their genitals, and abdominal pain, nausea, and the plaintiff missed 10 to 14 days of school. And the court said, this is clearly a denial of educational benefits and opportunities. So, again, it's really going to be a situation where it has to be reviewed by the court on a case-by-case basis. And just to put this in perspective for you, this is not something that you're going to be looking at in what you do in response to the actual notice. You know, it's not your role to say, well, you know, we don't think the kid was bothered that badly, so we're not going to do anything about it. This is solely for the court to determine as to whether or not, you know, the person can meet the standards of Title IX. And all of this is going to come into play, the deprivation of educational opportunities after the lawsuit has been filed. Now, one of the things I wanted to talk about that does come up a lot when you're talking about, you know, student harassment, and this is more from a teacher perspective than is anything, is that there are certain First Amendment issues that come into play. Because I get a lot of questions about, okay, given Title IX and given the climate that we're in with regard to sexual harassment, you know, what can we talk about in terms of curriculum? Do we have to stay away from certain curriculum that touches upon sensitive issues involving sex, race, sexual conduct, etc.? I mean, I'm sure that 50 Shades of Grey is not on the recommended reading list for any of you that are on this webinar, but, you know, there certainly are certain literary works that are very sexually suggestive, have a lot of sexual content in them, and the courts do recognize that there's a free speech right and that does apply in the campus and on campus in appropriate settings that would apply not only to just curriculum but might apply to newspapers, might apply to editorials, things of that nature that does exist. Now, in terms of the the curriculum, as long as it's part of the curriculum, for example, a sex education class, that's generally not going to be an issue. Newspapers, leaflets, school play, educational activities, those type of things are fine, as long as the curriculum is not being used as an excuse for somebody to be engaged in inappropriate behavior. Not unlike the situation of taking what could be seen as appropriate or legitimate touching and now turning it into an excuse to be engaged in inappropriate touching. And let's look at that. For example, college-level classes requiring reading of sexually explicit material that is demeaning to women from literary classics, and classes required to write their own, which are read in class and are also sexually explicit. Now, in that situation, the question that you would have in your mind if I would ask you when we were in front of each other is, do you think that this is going to be acceptable? Or is this going to cross the line in terms of whether or not this is someone who's using, the First Amendment and the curriculum excuse to get into some sexually inappropriate behavior? And actually, the courts have found that this type of discourse would not be a form of sexual harassment which would subject a teacher to discipline. Now, of course, this was the college setting. I know everyone would say to me, because we have a lot of K-12 people on the line, what about if this was in the high school? And again, I think it's going to depend upon what the circumstances are. Is this a curriculum that's normally used? Is this something that one teacher decided to put in front of the students that no one else has done before? What is the purpose for all of this? Again, all of this is going to have to be viewed on a case-by-case basis. There really is no right or wrong answer. Let's take another example. Male students repeatedly target a female student during a bus ride home, making sexual comments about her body and passing out sexual drawings amongst each other. Actual case situation. Even though there are some elements of free speech, in that particular case, the free speech is not protected by the First Amendment. So, the drawing, which someone would argue, well, that's freedom of expression, and the comments being made, freedom of speech. No. Are they speech? Yes. But there's a balancing test that's done that weighs the need for that speech versus the conduct involved, and that's typically how it's done. And in this case, it's pretty clear that that particular conduct would not be First Amendment protected. All right, so with all that said, you now know that you have actual notice. The question is, what do you do with that actual notice so that the court doesn't find that you're deliberately indifferent to the notice that you have? Well, this is not going to be, in my opinion, any different than if you had employee-to-employee harassment. You need to do a quick and thorough investigation. That's all you need to do, and take action. When did you receive the actual notice? Timing is critical in these cases. I think timing is critical in employee-to-employee cases as well, but more so in these cases than ever. You got to jump on these quick so someone can't say, well, you were deliberately indifferent because it took you a month to get around to doing this, all right? You have to take action right away. And, if that means putting someone on paid administrative leave, if it's a teacher, if that means taking a student and putting them out of the class for a period of time, depending upon the severity of the conduct, some action has to be taken as soon as possible. Because remember, the focus is on curtailing the activity. The focus is not on did you do a good investigation like in employee-employee cases. What have you done to curtail the activity? That's what the focus of the court's attention is going to be. And when I go through my scenarios, I'll tell you about how you get success on that. But that's really what the court wants to know. Right? And of course, it's a little bit different than employee-employer setting. When you're dealing with K-12 students, you've got the parent factor that you have to deal with. And a lot of people ask me, the parents want to be in on the investigation. Should the parents be allowed in? Ultimately, in the best case scenario, I would say, let's try to keep the parents out because I want you to hear what really happened from the student. I don't want to hear the parent's version of what happened to the student. And that's what you get more often than not. Tell them this, tell them that. What about this? What about that? We all know, and it's not unjustified, that when it comes to sexual misconduct, especially when you're talking about touching or sexual intercourse, it is very emotional for everyone involved, particularly the parents. And, you know, you have to deal with that. You want to get to the bottom of it as best you can. It's a sensitive issue, and hopefully you can convince the parents that, look, I need to speak to them, or if you're going to be here, I just want you to be here for moral support. Please don't say anything, you know, during my interview, you know, of your child. And most of the time, people say, should we hire an outside investigator? Well, I think it depends upon, you know, who we're dealing with. If it's a student-to-student situation, as long as you have somebody that's experienced in doing these investigations internally, I don't think it's necessary to go outside. Teacher to student, again, it depends upon the situation. I mean, a lot of public agencies now are just going outside because a lot of us attorneys tell you that, you know, it's going to look like a whitewash if somebody inside does it. You certainly don't want a teacher being investigated by someone who's a friend of his or might appear to be biased or prejudiced. Again, not unlike an employee-to-employee sexual harassment investigation. You're not required to hire an outside investigator, but if you do wind up hiring an outside investigator, please don't make it your general counsel. Because what winds up happening is all I get is arguments about, well, you know, they've been paid hundreds of thousands of dollars all year to give advice to this particular district. What did you expect them to say in their investigation? Now, the good news about this case is, unlike an employee-to-employee situation, is deliberate indifference generally will not go inside the nature and extent of the investigation unless, of course, it's a really bad investigation. And I want to spend about, I know we're almost getting to the 50-minute mark. I'm going to go through these really quickly, and then we'll take questions and answers. I had a non-sexual case many years ago involving 2 high school basketball teams, and an all African American basketball team showed up to play basketball at a predominantly white high school. And there were claims made that during the basketball game, there were kids in the stands shouting the N-word repeatedly. During the basketball game, they were wearing African American wigs. They were doing tribal chants. They were doing things clearly designed to demean the basketball team because they were African American. It was a huge story. It made the front page of the paper the very next day. There were complaints about it that were made during the game to a principal. And the principal, you know, couldn't find at the game who it was that was shouting the N-word. The people that were wearing the afros were asked to take them off, but they claimed they were not the ones chanting or doing the tribal chants. They were coming from somewhere else, and no one could determine where those chants were coming from or who was making them at the game. So immediately after that, within a week from then, the school district hired an outside investigator. They conducted 2 weeks of investigation, interviewed countless people. They tried to collect video that was taken from the game, and they could never determine who was shouting the N-word, or if in fact the N-word was being even shouted, because there was an argument being made by some people that what was heard to be the N-word was really some kids in the stands shouting a basketball player's last name that really did sound very much like someone who would be shouting the N-word. Long and the short of it is an investigation was conducted, and the result was inconclusive. They could not find anybody that did it, nor could they even determine that it was said or there were any really discriminatory practices going on at the game that could be proven. Lawsuit was filed claiming harassment. We defended the case. I filed a motion for summary judgment to dismiss the whole case, basically on the argument that, look, this district was not deliberately indifferent to the claims. Well, as it turns out, during the course of the litigation, some kid came out and admitted that he used the N-word during the basketball game. The kid was immediately disciplined, And the plaintiffs tried to use that to show, see, they didn't do a good investigation. Had they done their homework more, they would have found out that this kid, in fact, had said the N-word during the game instead of saying it could have been them shouting someone else's name. And the court said no. They said, you know what? They did a good investigation. They couldn't uncover this. There's no evidence to suggest that they were deliberately indifferent, despite whether or not there were damages to these students, despite clearly that it was severe enough given the statements that were made, and the entire case was dismissed. So I think that case is pretty illustrative of if you take immediate action and you take the right action, no matter how hideous the conduct was, and this was all over the newspapers for months up there in this district, it was dismissed. So I'm gonna hit the touchy-feely professor really quick. This was a situation where it was a demonstrative class. I think it was using EKG nodules on someone's chest, and the professor was using that as an excuse to show the students where these went, and instead of just placing them on two female students' bodies, according to them, he was actually moving his hands up and down and touching their breasts. And again, this was a case where once the entity found out about it, they took immediate action. The problem in this case was they sued for negligent hiring and negligent retention, and there were some issues of this professor being chastised or being complained about for other forms of inappropriate sexual behavior, which he was warned about in the past. And so as a result of that, we wound up negotiating a very reasonable settlement on that because we were concerned about how that would view, and we probably wouldn't get out on a motion for summary judgment. So I guess in finishing this up, and then we'll take some questions and questions if you have them, a lot of this really depends upon the circumstances, but when you find out about these, I think if immediate and appropriate action is taken, at least on the Title IX portion, you'll be able to minimize, if not escape, liability. So with that in mind, Marco, do you have any questions for me?
Sure, we've got a few that's come in. Thank you very much, Dennis. First off, organizationally, how should districts investigate instances and claims? What are the typical roles or functions or positions that would do the investigation at a district, both community college and K-12? Okay, well, obviously, this isn't a human resources issue if it's student to student. So a lot of times what will happen is who's ever involved, I've had situations before where the assistant principal in charge of student discipline will defer to somebody above them or him or her in terms of how it's done. So I don't see anybody in particular being the, quote, assigned person. If it's teacher to employee, that's clearly, or teacher to student, that's clearly a human resources issue. But on the student to student side, I think it does need to, depending upon the severity, it may need to go to a district level. Again, if we're talking about name calling and teasing and things of that nature, I think that somebody within the school can do it, but I think, again, that it has to be known by the district, and somebody at a district level has to decide how it's going to be handled. So I think any actual notice by a principal, an assistant principal, or anybody at that level, I think they really need to go above them and let someone know so that can be determined. Great. Thank you very much, Dennis. And I have another question. So the investigation is conducted, and it reveals that there were some instances of sexual harassment or any kind of harassment. What is done to protect the victim? What are some steps that can be taken to protect the victim?
Well, the first thing is you have to determine if it's student to student, or if it's teacher to student, you have to determine what level of appropriate discipline needs to be taken. That's number one. There has to be some level of discipline. And along with that discipline, there has to be a determination of how are we going to remedy this on a going forward basis, because remember the focus is on remedying. So if it's two students, as you saw in the one scenario I gave, I think that if it's a situation where they have to be removed so that they're not with each other, I've had cases before where it's been simple teasing and hasn't amounted to what we perceive to be sexual conduct, so we've had them agree that there's going to be a no-contact rule, that you two will not have any communication with each other, and if we see it, there's going to be further discipline taken, again, depending upon the severity of the situation. But again, if you're going to move somebody, it's not unlike the employee-employee setting. You don't want to move the victim because that's going to be seen as retaliatory. So whatever action you're going to take in terms of separating the parties, whether it's student-student, student-teacher, make sure that the action is taken against the harasser, particularly where you found that there was harassment. Now, if there's a determination that there wasn't harassment, I think you're on better ground to say, look, we don't, you know, if it's a problem moving the teacher, if it's a problem moving the student that's the harasser, you're on better footing going to the alleged victim and saying, look, we didn't conclude this, but if you like, you can transfer to another school, or you can do this, or we'll take some further action. A lot of it, I think, depends upon sitting down, if it's student to student, with the parents of the victim and seeing what do they want and how reasonable is that in making that determination.
Okay, fantastic. I've got one more question to share with you. Here's a question. A student's wife had a baby, and he took off to bond with the baby. His absences were not excused. His grades were impacted. Would this be a Title IX issue?
Okay, can you say that again slower for me?
It was a student who took off time to bond with his newborn child, and he had taken time off from school, and his grades were impacted. Would that be a Title IX issue, since his grades suffered, but he had taken time off to bond with the child?
Well, because there's no, I don't think that's conduct of a sexual nature or protection that he has as a student. Obviously, if he was an employee, it would be a different situation. So it's an interesting circumstance, but I don't think that per se is going to be a Title IX violation, unless, of course, he has some statutory right that I'm not aware of to take that time off. And even if he does, you know, unless he's asking for some assistance or something while he's gone, the fact that simply his grades went down, I don't think that's going to qualify as a Title IX violation.
Okay, great. Well, that wraps up our questions, Dennis. Thank you very much. And with that, I'll turn it back over to Charlotte.
Great. Thanks, Marco. And thank you, Dennis, for a great webinar today. Just to let everyone know that the recording of the webinar, as well as a PDF of the slides, will be posted on our website within the next few days. And also, I'll be sending everyone out an email with a brief survey that you can submit ideas for other webinars you'd like to see and that sort of thing. Also, we do have a bullying webinar series coming up in September, and information on that webinar series is on our website. So thanks again, everyone, for attending, and I look forward to seeing you on our next webinar. Thanks.
Yeah, and then if anybody else wants any further information or would like to get on any mailing list that I have, you have my email address. Please feel free to email me directly.
Great. Thanks, Dennis.
Thank you.
Thank you, everyone. Have a good day.